Okay.
Ready.
Okay, I'm going to mute myself.
Thank you, Ari. My name is Fran Gustin, and on behalf of Ari Katz and the entire CSP board, I want to welcome you to our 7th annual Supreme Court Year in Review with Dean Erwin Chemerinsky. This is our very first Zoom Year in Review. It has been my great honor to introduce Erwin the last 6 times he spoke to us. We would gather at University Synagogue in Irvine, and thanks to Erwin's popularity, we always had overflow crowds. So I want to give a quick shout out to Rabbi Arnie Rockles and the wonderful community at the University Synagogue for co-sponsoring and hosting Dean Chemerinsky's annual programs for us. Most of you already know that Dean Chemerinsky is one of the preeminent constitutional scholars of our time. He is currently Dean of Berkeley's Law School, which is one of the top-ranked law schools in the country. But we here in Irvine got to know him as the founding dean of UC Irvine School for several reasons. This was actually the first public law school established in the state of California in the last 45 years. And the school's articulated mission, its entire reason for being, was to promote social justice. So here's why we always got overflow crowds for Dean Chemerinsky's program. Number 1, he always explains things in plain English. Number 2, he is one of our nation's foremost advocates for individual rights and for civil liberties. Number 3, he is not afraid to speak truth to power, even if it means taking a case all the way to the Supreme Court, which he has done on numerous occasions. In sum, Dean Chemerinsky has spent his life upholding the most important religious principles articulated in the Torah, which says, quote, justice shall you pursue, close quote. I can't think of anyone who's worked harder or more tirelessly to bring those immortal words to life. It is therefore my very great pleasure to welcome you back to the CSP. We thank you for joining us again. Back over to you, Erwin and Ari.
Thank you. Thank you so much for that incredibly sweet and kind introduction. It's truly my great pleasure to be able to do this program. I wish we could all be live together in the sanctuary at University Synagogue, but we have to do it through this medium now. I do hope this finds everyone and all of your loved ones healthy and safe at this very difficult time. I was trying to think about what to title my presentation this year, and I was thinking maybe I would call it, "Why is this term different from all other terms?" Well, to start with, the court is likely to decide fewer cases this year than any in recent memory. If the court decides all of the remaining cases on its docket that have been argued, there'll be 54 decisions. That's the fewest number since 1864. Another thing that's different is there were 2 months this year where oral arguments were canceled. The justices canceled their oral arguments in March and April because of the pandemic. The last time the justices canceled the month of oral arguments was in October 1918, when the court did so because of the Spanish flu. The court rescheduled some of those cases to be heard in May, but put 10 of them over to be heard next year. This was the first time in history that the Supreme Court held oral argument by telephone. It's interesting that the justices didn't choose a medium like this, Zoom, but had telephonic oral arguments. It's the first time ever that there was live broadcasting of Supreme Court arguments. The justices have been very reluctant to have any kind of media presence, cameras in the courtroom, audio broadcasts, but they did. It's the first time in over 30 years that the justices won't be done by July 1st. Tradition is the justices decide all the cases argued in a term by the end of June, but not this year. And the reason for that is because they had to postpone oral arguments to May, and since there were later oral arguments, there'll likely be decisions coming down, I'd say in the next couple of weeks to finish out the term. But maybe most of all, what makes this term different from all other terms is the number of blockbuster and potential blockbuster cases on the docket. Been a law professor for 40 years now. I can't think of a year where there are as many blockbusters and potential blockbuster cases as this term. These are decisions that affect so many people, often the most important, the most intimate aspects of their lives. So let me talk about some of the cases that I regard as most important, and I promise to save time for your questions. The first area that I want to talk about concerns gay, lesbian, and transgender rights. It's a case that came down 2 weeks ago yesterday, on Monday, June 15th. The case is called Vostok versus Clayton County, Georgia. It actually was 3 cases that came to the Supreme Court together. Vostok itself involved somebody who worked at a child welfare office. He joined a gay softball team, and when his employer found out, his employer fired him saying, "I don't want to be employing a gay individual." There was a companion case, Zarda versus Altitude Express. It involved a skydiving instructor. And when the instructor's boss found out that the skydiving instructor was gay, the boss said, "You're fired." The final case involved Amy Stevens. Amy Stevens had worked at the Harris Funeral Home for 6 years as a funeral director. She then informed the employer that she was transitioning, that she wished to be addressed as Amy, and that henceforth she'd be wearing the clothes of a female funeral director, a skirt rather than a coat and tie. The employer said, "I don't want to employ a transgender individual, you're fired." All 3 of these individuals had been long-standing employees, all had outstanding performance records. Each was fired on account of sexual orientation or gender identity. Here's the issue. Title VII of the 1964 Civil Rights Act prohibits employment discrimination based on race, sex, or religion. Specifically, it says that it forbids discrimination, quote, "because of sex." Is firing somebody for being transgender or for being gay or lesbian discrimination because of sex? In a 6-3 decision, the Supreme Court said, yes, such discrimination violates Title VII. Justice Neil Gorsuch wrote the opinion for the court, joined by Chief Justice Roberts, as well as Justices Ginsburg, Breyer, Sonair, and Kagan. Justice Samuel Alito wrote a vehement 100-page dissent. His dissent was so long that it crashed the Supreme Court's website on that day. And his dissent was joined by Justice Thomas. Justice Kavanaugh wrote a separate, shorter dissent. Justice Gorsuch says he interprets statutes based on their plain language. He said that the plain meaning of "because of sex" is a prohibition of discrimination because of sexual orientation and gender identity. Let there be no doubt. The holding was clear and emphatic. Let me read you what Justice Gorsuch wrote. In Title VII, Congress adopted broad language, making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an employee merely for being gay or transgender defies the law. I think a simple example illustrates the basis for Justice Gorsuch's conclusion. Imagine an employee named Chris. Imagine that Chris and the employer have never met. They talk by email or text. Chris is often referred to a husband in discussing weekend or vacation plans. The employer always assumed that Chris was a man, or Chris was a woman. When the employer meets Chris, the employer is surprised to see that Chris is male. The employer thinks a second and says, "I don't want a gay person working for me, you're fired." If Chris were female, Chris would still have that job. But because Chris is male, Chris has lost the job. That, Justice Gorsuch would say, is discrimination because of sex. Same with regard to Amy Stevens. If Amy Stevens were male, she would still have her job as a funeral home director. but because she's female, she's been fired. That's discrimination because of sex. Justice Gorsuch, writing with the court, said, it doesn't matter what Congress intended in 1964. We look at the language of the statute. The statute forbids discrimination because of sex. Firing a transgender or gay or lesbian individual is firing because of sex. Now, the argument was made to the Supreme Court, including by the Trump administration, that it's not sex discrimination because a gay man or a lesbian woman will be fired, a transgender man or a transgender woman will be fired, so no one's being discriminated against that kind of sex. But the Supreme Court says, you need to look at the individual level. And the individual who does not have the job because he or she is gay, because he or she is transgender, that then is discrimination that violates Title VII. As I said, Justice Alito wrote a vehement, vitriolic dissent. He too focused on plain language. He said, when we use the words sex discrimination, we mean something different than we're talking about sexual orientation or gender identity discrimination. He said, Congress could have amended Title VII to prohibit this, but it didn't. He says that this is going to raise all sorts of problems. What does it mean for privacy and the use of bathrooms? What does it mean for athletics and say women's sports? Do they have to accept transgender women? And he went on with what he thinks would be the ill effects of this decision. Justice Kavanaugh wrote a separate dissent. Justice Kavanaugh said, this should be for Congress, not for the court. There have been bills in Congress to amend Title VII to prohibit discrimination based on sexual orientation or gender identity. They haven't been passed. He says, we should wait for Congress to do this. Well, why does this decision matter so much? First, it means that federal law now prohibits employment discrimination on the basis of sexual orientation or gender identity. Only about half the states have laws that prohibit such discrimination as a matter of state law. Of course, what that means is in about half the states, gay, lesbian, and transgender individuals had no protection against employment discrimination. Now they do. Second, this is going to have implications for laws in other areas. There are about 100 different federal statutes that prohibit discrimination because of sex. They're in so many different contexts: housing, and health, and education. It would seem that in all of these areas, the statutes now have to be interpreted to also prohibit discrimination on the basis of sexual orientation or gender identity. The Obama administration had promulgated rules and issued guidance letters saying these laws should be interpreted to prohibit discrimination on the basis of sexual orientation or gender identity. The Trump administration rescinded all of those. Now it would seem that it's irrelevant what the executive branch does because the statute itself is prohibiting discrimination on the basis of sexual orientation or gender identity. Let me give an example. Title IX of the Civil Rights Act says that educational institutions that receive federal funds cannot discriminate on the basis of sex. The Obama administration in a guidance letter said this also prohibits discrimination against transgender individuals. The Trump administration rescinded the guidance letter. But now it would seem that Title IX itself says that educational institutions that receive federal funds can't discriminate against gay, lesbian, or transgender individuals. This is going to lead to a lot of litigation. Some is already pending. An issue that's going to come up is, do transgender women have the right to participate in women's sports? Transgender women argue that to exclude them is to discriminate against them. Anybody else could participate in competitive interscholastic sports, but not transgender women. But those who support the exclusion say that it's different because transgender women, by virtue of physiology and anatomy, will have an advantage over other women and will harm competitive sports for women. As I said, there's also going to be issues about what this means in terms of access to bathrooms on the job and the like. I think it's going to mean that employers must recognize the transgender status of a person an individual's gender identity when it comes to bathrooms, locker rooms, and the like. Third implication is going to be for religious discrimination. What if there's an employer who says, it violates my religion to have to employ a gay, lesbian, or transgender individual? Does free exercise of religion protect the ability to discriminate in this way? Justice Alito stressed this point in his dissent. Justice Gorsuch said, it's not an issue before the court right now, so it's not going to be resolved. But this is a court that I think is going to be very protective of free exercise of religion. Title VII itself has a very narrow exception protecting religious discrimination. It would say, for example, a Catholic church doesn't have to hire a woman as a priest or a man as a nun, or an Orthodox synagogue doesn't have to hire a woman as a rabbi. But Title VII is quite restrictive in its exception for religious discrimination. But there's a federal statute, the Religious Freedom Restoration Act, that has much more protection for free exercise of religion. And of course, there's the First Amendment provision that protects free exercise of religion. All of these are claims that are going to come up. But by any measure, this is a case of enormous significance in protecting gays, lesbian, transgender individuals from employment discrimination. The second major case that I want to talk about concerns Daca, the Deferred Action for Childhood Arrivals program. The case is Department of Homeland Security versus University of California. Daca was adopted through an executive order by President Barack Obama. It applies to individuals who were brought to the United States when they were younger than the age of 15 and were younger than 30 at the time the program was adopted. In order for a person to qualify for Daca, he or she has to be enrolled in school or successfully graduated, or in the military, or be honorably discharged. The law says that for an individual to qualify, he or she cannot have a felony conviction or conviction for a serious misdemeanor. The effect of receiving Daca status is that a person then receives, under federal immigration law, what's called deferred deportation status. Deferred deportation status means that the person doesn't have to fear being deported in the next 2 years. Also, the person is entitled to a work permit and other privileges. It's estimated about 800,000 individuals benefit from Daca. There are many on my campus and in my law school who are Daca recipients. After some reflection, President Trump rescinded Daca. 3 federal district courts declared this impermissible. The United States Court of Appeals for the Ninth Circuit affirmed. 2 weeks ago, on Thursday, June 18th, the Supreme Court in a 5-4 decision held that President Trump violated the Administrative Procedures Act in rescinding Daca. Now, like Vostok versus Clayton County, Georgia, this was not a constitutional decision. This case was about the Administrative Procedures Act. The Administrative Procedures Act says that when federal agencies act, they cannot act in a manner that's arbitrary or capricious. And the court has said that this requires that there be an articulated, legitimate reason for the agency action. The Supreme Court held 5-4 that President Trump's rescission of Daca was arbitrary and capricious. Chief Justice John Roberts wrote the opinion for the court. He was joined by Justices Ginsburg, Breyer, Senator, and Kagan. Chief Justice Roberts said that when Daca was rescinded, only one reason was given, and that's that President Trump believed it to be illegal. And there was no consideration of other alternatives. Daca has 2 parts. One gives deferred deportation status. The other confers benefits like the ability to get work permits. The court said should have been considered whether these could be severed and perhaps only one repealed. The justifications for keeping Daca were never considered. The court said, therefore, there isn't an articulated, legitimate reason it's arbitrary and capricious. I think to understand the decision, I need to put together with a Supreme Court ruling from almost exactly a year ago, the Department of Commerce versus New York. You might remember that this case involved a choice by the Trump administration to add a question about citizenship to the 2020 census. Now, what happened with regard to that was the Department of Commerce went to the Department of Justice and said, would it help you if we ask a question about citizenship on the 2020 census? The Department of Justice said, no, we don't need it. The Department of Commerce then went to the Department of Homeland Security and said, would it help you if we asked a question about citizenship on the 2020 census? The Department of Homeland Security said, no, we don't need it. Then the Secretary of Commerce, Wilbur Ross, went to the then Attorney General, Jeff Sessions, and said, really, wouldn't it help you if we asked a question about citizenship? And Jeff Sessions said, sure, it'll help us enforce the Voting Rights Act. But there was no evidence of that. There's no evidence of not knowing of citizenship in the answer to census questions had anything to do with enforcing the Voting Rights Act. And the Supreme Court 5-4 invalidated the action of President Trump. Once more, John Roberts wrote, once more joined by Justice Ginsburg, Breyer, and Kagan. He said there has to be an articulated legitimate reason for an executive action, and none existed here. What's the significance of this case? 800,000 individuals retain their Daca status. If the Supreme Court had come out the other way, then all of these individuals could face immediate deportation. All would lose their work privileges. Now, this may not be over. President Trump reacted angrily to the decision. He said he's going to issue a new executive order to rescind Daca. Of course, he can do so. The Supreme Court did not hold that the president cannot rescind Daca. The Supreme Court held that President Trump did so without providing an adequate, articulated, legitimate justification. So he could try to rescind Daca again, just giving a clearer, more full explanation. Perhaps the politics will keep President Trump from doing this. Daca is very popular with both Democratic and Republican voters. Even if President Trump does this, it's sure to be challenged and tied up in the courts for many months. If President Trump is reelected, he could reissue the rescission of Daca. But if Joe Biden is elected, there's no doubt that Daca will continue. And of course, Congress could resolve all of this. Congress has broad powers to immigration. And if Congress wanted to, Congress by statute could give them permanent Daca status or a path to citizenship, or even citizenship itself. The third area that I was going to talk about this afternoon concerns abortion rights. And here I want to talk about a case that came down just yesterday, June 29th. The case is June Medical Center versus Russo. Louisiana adopted a law that said any doctor performing an abortion had to have admitting privileges at a hospital within 30 miles. The hospitals generally will not give the doctors admitting privileges, so it then effectively keeps them from being doctors to perform abortions. If this sounds familiar, it's because 4 years ago, the Supreme Court declared unconstitutional an identical Texas law. And I mean identical because what Louisiana did was simply copy that Texas statute. The Texas law said that in order for a doctor to perform an abortion, the doctor had admitting privileges within 30 miles. In Whole Women's Health versus Hellerstedt in 2016, the Supreme Court 5-3 declared the Texas law unconstitutional. Justice Stephen Breyer wrote in that case, joined by Justice Kennedy and also Justices Ginsburg, Sotomayor, and Kagan. Justice Breyer said the requirement for admitting privileges was an undue burden on a woman's right to abortion. He said that there's no evidence that this will do anything to protect women's health. Rarely do women who are having abortions need to be hospitalized. If they do, the doctors at those facilities will provide treatment. At the same time, he said, this could close many facilities in Texas where abortions are performed. There are a number of states that adopted laws like the Texas one. Federal district courts across the country invalidated those laws. Federal District Court in Baton Rouge, Louisiana, struck down the Louisiana statute. But the United States Court of Appeals for the Fifth Circuit, in a 2-1 decision, reversed. The majority said that there weren't the detailed factual findings with regard to the Louisiana law as they existed with regard to the Texas law. Judge Patrick Higginbotham, a conservative judge, wrote a dissent and said, "This case is just like Whole Women's Health versus Hellerstedt. There's no reason to draw a distinction between this and that." Yesterday, 5-4, the Supreme Court reversed the Fifth Circuit and declared the Louisiana law unconstitutional. Justice Breyer wrote the plurality opinion, joined by Justices Ginsburg, Sotomayor, and Kagan. Justice Breyer said, like in Whole Women's Health, the Texas law will do nothing to protect women's health, but it will impede access to abortion. It won't do anything to protect women's health because rarely do women need to be hospitalized, and if they are, the doctors at the local hospital provide treatment. And he said, we will close facilities in Louisiana where abortions are performed. The surprise yesterday was that Chief Justice Roberts was the 5th vote for the majority. He concurred in the judgment. He said, in Whole Women's Health versus Hellerstedt, we said that such laws are unconstitutional. This case is indistinguishable from the Texas statute. Therefore, we must follow the principles of stare decisis and declare the Louisiana law unconstitutional. He said, I dissented in Whole Women's Health. I believe that decision was wrong, but as a justice, I have to follow stare decisis. Strong dissenting opinions. Justice Alito again wrote a vehement dissent. Justice Thomas wrote again to say that he believes that Roe versus Wade was wrongly decided. Why does the case matter? Well, at the very least, it means laws like the Louisiana and the Texas law are unconstitutional. In fact, since the year 2010, 35 states have adopted over 500 new laws imposing restrictions on abortion. These are sometimes called targeted restriction of abortion provider statutes. I think that this case suggests that many of them may be unconstitutional. The largest significance with regard to this case is Chief Justice Roberts' vote. John Roberts came onto the Supreme Court in the fall of 2005. From then until yesterday, June 29th, 2020, never, not once, did John Roberts vote to strike down any restriction on abortion. But yesterday, he was the 5th vote for the majority. He stressed precedent and stare decisis. In so many other cases in the last few years, John Roberts has joined with the majority in overruling precedent. But here he follows it. Does this then suggest that he's more likely to vote to follow precedent to reaffirm Roe versus Wade or Planned Parenthood versus Casey? All the court decided yesterday was that the Louisiana law is unconstitutional. But Chief Justice Roberts being the 5th vote for that result is so significant for abortion rights for the future. Obviously, all of this could depend again on who wins the November 2020 election. If President Trump can replace one of the liberal justices with a staunch conservative, then Roe is sure to be overruled. But no longer does it seem certain that there are 5 votes on the current court to overrule Roe versus Wade. The 4th area of cases I want to talk about today concerns religion. And this is going to be a major term of the court when it comes to religious freedom. As I alluded to, I think that the 5 conservative justices want to provide much more protection for religious freedom, including religious freedom to discriminate, religious freedom to deny benefits to others. We're going to see this manifest itself in a number of cases this term. Let me talk about 3 sets of cases. The first is Espinoza versus Montana Department of Revenue. It was decided just this morning. Montana adopted a law through its legislature that gave tax credits to parents who were sending their children to private school. Parents who sent their children to private school could get a $150 tax credit. Didn't matter whether it be a secular private school or a religious school, there'd still be the tax credit. The Montana Supreme Court declared this unconstitutional as violating the Montana state constitution. The Montana Constitution has a provision, like most states do in their state constitutions, that prohibits the state from giving any direct or indirect aid to religion. This was adopted in many states as a result of what were called Blaine Amendments in the 19th century. James Blaine was a United States Senator, and he often introduced bills that said, in order for a state to be admitted to the Union, it have a provision in its constitution prohibiting direct or indirect aid to religion. As Justice Alito argues in an opinion released this morning, he thinks that that really motivated by anti-Catholic sentiment, and there's strong evidence that the Blaine Amendments were motivated by this. But I should also stress, many states have prohibitions against direct or indirect aid to religion, even apart from the Blaine Amendments. New Jersey, for example, prohibits government aid to religion, and its provision long predates the United States Constitution. The Montana Supreme Court, as I said, struck down the Montana law as violating the Montana Constitution. One would think that that would be the end of the litigation. There is no longer a state statute. It no longer discriminates against religion. But this morning, in a 5-4 decision, the Supreme Court held that the action of the Montana Supreme Court violated free exercise of religion. Chief Justice Roberts wrote, joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. You had very strong dissenting opinions written by Justice Ginsburg, Justice Breyer, joined by Justice Kagan, and Justice Sotomayor. Chief Justice Roberts said, it's odious to deny a religious institution that which is provided to a secular institution. Said the government has to meet exacting review. They'll have to meet strict scrutiny when it does that. The court relied heavily on a decision from 3 years ago. The case was Trinity Lutheran of Columbia, Missouri versus Comer. It involved a Missouri program that took scrap tires, shredded them, and made a substance on the bottom of playgrounds so if a kid fell, there'd be a soft landing spot. Missouri gave aid to schools to buy this playground surface if the schools were public or secular schools. It wouldn't give the money to religious schools. It refused based on a provision of the Missouri Constitution that prohibited direct or indirect aid to religion. The Supreme Court found unconstitutional Missouri's denial of aid to religious schools. Once more, Chief Justice Roberts wrote the opinion for the court. Now, the question was immediately asked, what does this apply to? In footnote 3 in Trinity Lutheran, Chief Justice Roberts said, this is just about aid to playgrounds and nothing else. But we know that's not how the law works. And so the claim was that this would then lead to discrimination. This would then mean that religious schools would be entitled to benefits beyond just aid to playgrounds. I think that is exactly the implication of Espinoza versus Montana Department of Revenue from this morning. I think what the court is saying in this context is, anytime the government gives aid to secular private schools, it must give that same aid to religious schools. This is a dramatic change in the law. Up until recently, the litigation has always been about what kind of aid can the government permissively give to religious schools. Now it is, when is the government constitutionally obligated to give aid to religious schools? And I think the bottom line answer of the Supreme Court is the government must give the aid to religious schools if it's giving the aid to secular private schools, unless there be some way of arguing that that particular type of aid when given violates the Establishment Clause. 5-4, Chief Justice Roberts writing for the majority. The second case that I've listed is, or what I'm going to talk about with regard to religion, is St. James School versus BL and Our Lady of Guadalupe School. what's involved in these cases is a very important question. Are religious schools exempt from anti-discrimination law? Both of these cases involve religious schools that fired elementary school teachers. When the schools were sued with regard to employment discrimination, they said, we're a religious school. You can't hold us liable for employment discrimination because we get to choose who's going to teach our religion. Now, this goes back to a Supreme Court decision from 2011, Rosanna Tabor Lutheran School versus EEOC. That case involved a 5th grade teacher, Cheryl Pryke, at a religious school. She had been ordained as a minister in the faith. She became ill. She needed to take time off work. And when she came back and said, I'm healthy, I want a job, they said, sorry, we filled all the positions. When she complained about it, they said, you're being insubordinate, you're fired. She sued and said that her firing violated the Americans with Disabilities Act. The lower courts agreed with her, but the Supreme Court ruled against her. Chief Justice Roberts wrote the opinion to the court and said, she's been ordained as a minister. To hold a religious institution liable for the choices it makes to who will be a minister violates free exercise of religion. What makes the Guadalupe and the St. James cases different is they did not involve teachers that were ordained as ministers. In fact, there's even a dispute over how much religion these teachers are responsible for instructing. The schools say religion permeates the curriculum, so the school is required to be able to fire teachers who don't properly teach religious dogma. The teachers say, we're teaching secular subjects. Religion is incidental. The school shouldn't be able to fire us. But the question, there's no doubt that it's what it's about. To what extent are religious schools or religious institutions broadly exempt from employment discrimination law? The third set of cases that are listed is Little Sisters of the Poor versus Pennsylvania and Trump versus Pennsylvania. These two cases, which are consolidated for argument and decision, involve the so-called individual mandate under the Affordable Care Act. And specifically, it involves an aspect of it, the contraceptive mandate. The contraceptive mandate says that employers must include in their insurance coverage payment for the types of contraceptives for women that are approved by the Food and Drug Administration. The way in which the Affordable Care Act and the regulations under it are written, there are 3 categories of employers. One is religious institutions themselves when they oppose contraception. Think of the Catholic Church. It does not have to provide contraceptive coverage in its insurance for women employees. A second category of employers are not-for-profits that are affiliated with religions that oppose contraception. Think of a Catholic university or Little Sisters of the Poor. And the final category are all other employers. And they are required in providing insurance to include coverage for the types of contraceptives approved by the Food and Drug Administration. But you might remember 6 years ago, in 2014, in Burwell versus Hobby Lobby, the Supreme Court said it violated the federal freedom, the Religious Freedom Restoration Act, RFRA, to force a family-owned business, a close corporation, to provide contraceptive coverage if it violated the owner's religious beliefs. Well, immediately the issue was litigated. What about the second category? What about not-for-profits that are affiliated with religions that oppose contraception, like the Catholic Church, like a Catholic hospital, or Little Sisters of the Poor? The Supreme Court had this issue before it in 2016, but before the court could decide, Justice Scalia passed away, and the justices were split 4-4. The cases were sent back to the lower courts. Now they're before the Supreme Court. The not-for-profits that are affiliated with religions say to the Supreme Court, what we're required under the law to do is to tell our insurance provider that we don't want contraceptive coverage for women employees. then under the terms of the law, the employer is required to provide contraceptive coverage at no cost to the women employees. The religious institutions like Little Sisters of the Poor say, this makes us complicit by telling the insurance provider we don't want such insurance coverage. The insurance provider is making sure there's contraceptive coverage. Such complicity violates free exercise of religion. Also, the Trump administration expanded the exemption to also include employers who oppose contraception on ideological or philosophical grounds. Is that permissible? All of that's before the court. So you put the religion cases together, I think what you're going to see is one place where the shift in the composition of the court makes a huge difference is with regard to protecting religious freedom. The final cases I want to talk about, and then I'll use the rest of the time for questions, concern subpoenas directed at President Trump's financial institutions. The subpoenas directed at the accountants, the banks with whom President Trump does business. There are 3 cases, and they haven't been decided yet. One is Trump versus Vance. A grand jury in state court in New York was investigating whether President Trump violated federal campaign finance laws with regard to the payment of hush money to Stormy Daniels in the 2016 campaign. We know because of Michael Cohen's revelations that Stormy Daniels was given over $100,000 so as to remain silent, tell anybody about her sexual relationship with Donald Trump. Campaign finance laws prohibit expenditures and giving something of value in this way. There's a strong argument that this, because of its value, should have been seen with regard to the lens of campaign contributions and expenditures. So the grand jury subpoenaed the records from President Trump's accountant, Mazars USA. President Trump then went to federal district court for a subpoena, to quash the subpoena directed at Mazars. The district court ruled against him. The district court said, this isn't directed at you. And besides that, it's investigating what occurred prior to the time you were elected as president. In 2016, in 1997, in Clinton versus Jones, the Supreme Court said a president has no immunity for acts that occurred prior to taking office. And the federal district court said, this was before you took office. The Second Circuit affirmed. The Supreme Court granted review. There are 2 other cases that came separately, though they were consolidated for briefing and oral argument. It's Trump versus Deutsche Bank and Trump versus Mazars USA. Both involved congressional committees that were investigating alleged wrongdoing by President Trump in connection with the dealings with Russia. They were also trying to gather information to see what kind of future legislation would be appropriate. In each instance, President Trump went to federal district court. He wanted the Southern District of New York to quash the subpoena directed at Deutsche Bank, and it refused. The Second Circuit affirmed. He went to federal district court in Washington to quash the subpoena directed at Mazars. It refused, and the DC Circuit affirmed. So what you have then is a number of different courts considered the issue, all came to the same conclusion. All said that President Trump could not quash the subpoenas directed at the financial institutions. Why are these cases likely to matter so much? Well, I have always thought that the core of the rule of law is that no one, not even the president, is above the law. And I think these questions are going to be, well, can the president be subpoenaed? Or more specifically, can the financial institutions doing business with the president be subpoenaed? Or is the president so above the law that there can be no investigation? The cases were argued on Tuesday, May 12th. I expect they'll be among the latest cases to come down. Mid-July would be my guess. I often say to my students that the important thing about looking at what the Supreme Court does is how much it affects all of us. Frequently the most important, the most intimate aspects of our lives. And you certainly see that in the cases that I've just reviewed. So at this point, I've talked a little more than 45 minutes, and I'm glad to use the remaining time for questions.
Okay, so people are chatting questions, and while they continue to chat them, I'll ask some of them and some of my own. Going back to the last series of cases, the taxes, president's taxes, what is your prediction as to what will be decided when it's finally decided in July?
Predictions are free and worth what they cost. If you had asked me how I was going to predict what the Supreme Court was going to do in Vostok or in the Daca case or the abortion case, I would have predicted wrong. So I'm not the person you want to take with you to Las Vegas and bet on my predictions. That said, I think what the Supreme Court's going to do is reverse the lower courts and say that if it's a subpoena that involves financial records of the president, there has to be a heightened showing of need. And they're going to remand to the lower court to see if the heightened showing of need standard was met.
Okay, we'll see what they decide. Can you say a little bit about the Roberts Court now? What has happened? Is this a major tectonic shift in the court, or are the decisions that have come out, which have been surprising, decided on such narrow grounds that we can't predict forward as to what will happen in the next few years?
I think it is clearly the Roberts Court now. Now, in one sense, it's been the Roberts Court since 2005. But the reality is that until 2018, it was more the Kennedy Court than the Roberts Court. Kennedy was the swing justice, and lawyers knew it, parties knew it, the justices knew it. When Kennedy was replaced by Kavanaugh, he was replaced by somebody significantly more conservative. So John Roberts became what political scientists would call the median justice, the justice in the middle ideologically. Now, John Roberts overall is very conservative. As I mentioned, he had never voted to strike down any restriction on abortion until yesterday. He's always voted against affirmative action. In the marriage equality case in 2015, Obergefell versus Hodges, he wrote an angry dissent. In fact, the only dissent that John Roberts ever read from the bench was an Obergefell. But 3 times over a couple of week period, in the Title VII case, the Daca case, and the abortion case, John Roberts was the liberal justices. It's happened before. In 2012, in National Federation in Business versus Sebelius, John Roberts was the 5th justice to uphold the Affordable Care Act. Last year, as I mentioned, in Department of Commerce versus New York, Chief Justice Roberts was the 5th vote to keep a question on citizenship from being on the 2020 census. But it's clear that Roberts is occupying a more centrist role now. I don't want to guess as to his motivations. Maybe it's as Chief Justice, he sees more responsibility for the institutional legitimacy of the court, but for every reason, those rulings are striking.
Can you give us an update as to the status of the Emoluments cases? I think you were involved in one or many, and tell us what's going on.
They're being litigated. There's 3 different cases. The one that I was involved in was filed on January 23rd, 2017. It's on behalf of hotels and restaurants, hotel and restaurant workers in a public interest organization. The district court dismissed, the Second Circuit reversed, and it's slowly going forward. There was a case that was filed by a couple of attorney generals, and it argued that the president is violating the Emoluments Clause. The district court allowed the case to go forward. The Fourth Circuit reversed, and is now before the whole Fourth Circuit. Third case was brought by members of Congress claiming a violation of the Emoluments Clause. It's been dismissed, but that's on appeal. I think it says something not good about our judicial system, that you're dealing here with lawsuits that were filed in 2017. We're on June 30th, 2020, and the litigation is just meandering along. Every day, I believe that President Trump is violating the Emoluments Clause by getting financial benefits from foreign governments and financial benefits from the United States government beyond the salary that he's paid.
Can we pivot to the Affordable Care Act and find out from you what's going on with that, and whether that will be on the docket for, for next year for the Supreme Court, and where they may go with that?
The Affordable Care Act is often called Obamacare. It's estimated that it was adopted, it provided additional health insurance to 40 to 50 million people. Because what's happened since, it's now estimated that if the Affordable Care Act is repealed, about 22 million people will lose their health insurance. And if ever it was unthinkable, that certainly is so in the midst of a pandemic. The centerpiece of the Affordable Care Act was what was called the individual mandate. I've already alluded to it. It said that everybody had to purchase health insurance or pay a tax penalty by the year 2016. In 2012, in National Federation of Independent Business v. Sebelius, the Supreme Court upheld the constitutionality of the Affordable Care Act. 2 years ago, Congress repealed the individual mandate. No longer will somebody be penalized if they don't have health insurance. But the rest of the Affordable Care Act still remains in place. The Affordable Care Act is about 2,600 pages long. It includes so many things beyond the individual mandate. It prohibits insurance companies from denying insurance to people based on pre-existing health conditions. It says that insurance companies can't have a cap on yearly or lifetime benefits. It says insurance companies can't charge more to people who have chronic conditions, and so on for 2,600 pages. Nonetheless, a federal court of appeals, the United States Court of Appeals for the Fifth Circuit, Texas area, 2-1 said the entire Affordable Care Act is unconstitutional. They said the Supreme Court has identified the individual mandate is the core of the Affordable Care Act. If the individual mandate has been repealed, then the entire Affordable Care Act is unconstitutional. The dissenting judge said, that's nonsense. Congress could have passed the Affordable Care Act without an individual mandate. Therefore, this is the same as that. There is a principle in law called severability, of deciding if one provision of a law is unconstitutional, does the rest of the law also get struck down or is the rest upheld? But this isn't the court striking down any part of the law. This is Congress repealing part of the law. The underlying question for severability always is, what was congressional intent? But Congress's intent here seems clear. Congress didn't want to repeal the Affordable Care Act. It tried, but it didn't have the votes. Last Thursday, the Trump administration filed a brief in the Supreme Court asking it to declare the entire Affordable Care Act unconstitutional. I've often thought that the Trump administration is quite insensitive to those who are suffering because of the pandemic, those who have died as a result of the pandemic. The idea of having the Affordable Care Act declared unconstitutional in the midst of the pandemic is enormously disturbing. But that's their position, and the case will be argued in the Supreme Court in the fall.
Can you give us a heads up as to some other big cases that will be coming up for the next term that we should be aware of?
Fulton versus City of Philadelphia, Pennsylvania. It involves free exercise of religion. It involves whether or not Philadelphia must allow the Catholic Church to be able to be involved in foster care and adoption decisions in light of the Catholic Church refusing to place children with gay, lesbian, transgender foster or adoptive parents. Philadelphia says, we require that anyone who participates in this not discriminate based on sexual orientation or gender identity, and that's what you're doing. The religious institution says, but we should have free exercise of religion, and you're infringing that by not allowing it. Here's why the case is so important. There is going to be a real tension between the desire for equality, stopping discrimination, and religious freedom. It's going to come up in the context of the workplace, I said, with regard to Vostok versus Clayton County, Georgia. An employer says, my religion is violated by having to have a gay, lesbian, or transgender employee, versus on the other hand, the protection of equality and making sure that people aren't discriminated against because of gender identity or sexual orientation. The other thing that makes the case important, in 1990, in Employment Division versus Smith, the Supreme Court said the Free Exercise Clause of the First Amendment cannot be used to challenge a neutral law of general applicability, no matter how much it burdens religion. To put that in plain English, what the Supreme Court says is if there's a general law in the books, a religion doesn't get an exception from it. That case involved Native Americans in Oregon who wanted to use peyote in religious observances. Oregon law didn't have an exception for this. It just prohibited peyote. The Supreme Court, in an opinion by Justice Scalia, said the religious institution doesn't get an exception. It said that the Oregon law was neutral and that it was not motivated by desire to interfere with religion. So general applicability, it applies to everyone. The court said no exception on the basis of religion. One of the key issues that's granted in Fulton versus City of Philadelphia, Pennsylvania, is whether to overrule Employment Division versus Smith. And as I said, if you look at the religion cases that are still to be decided in the next couple of weeks, in Fulton versus City of Philadelphia, Pennsylvania, I think where we're going to really see the conservatives in the Roberts Court is with regard to religion.
In our final few minutes, we had a great question. Is there a book on the Supreme Court that you could recommend to this lay group of, well, it's a mixture of lawyers and mostly non-lawyers, so they can read up on the Supreme Court and learn more about this important third branch of government?
Sure. Richard Fallon has a book that you can get on Amazon on the, I think it's called The Supreme Court in American Society or something like that. That's quite good. David Kaplan wrote a book that came out last year called The Most Dangerous Branch. And I'll do a plug. I have a book that came out several years ago called The Case Against the Supreme Court, and it was published by Viking in 2014.
Yeah. Someone has asked, are any cases coming out about the Electoral College that we should be aware about?
Yes, there is some cases pending right now before the Electoral College. It's Chiafalo versus Washington and Colorado Department of State versus Daca. And those cases involve whether a state can prescribe how an elector must vote in the Electoral College. All states, except for Maine and Nebraska, follow winner take all with regard to Electoral College. Whoever gets the most popular votes in California is going to get all of California's electoral votes. But what if California goes for Joe Biden, but some elector says, I'd rather have Donald Trump? What if a lot of electors say they'd rather have Donald Trump? Or vice versa? Can the state say, you have to vote this way? Or does the elector have a First Amendment right to vote how he or she chooses? These cases were argued in May as well and are likely to be decided in the next couple of weeks.
Oh, terrific. Well, we have a lot to look forward to. My last question to you is, who is your foil on the right as being a constitutional law professor who represents more of a right-wing perspective on issues that you respect the most? It's always nice to know who do you like to go up against in?
Oh, there's so many. John Manning, who's the Dean of Harvard Law School.
Mm-hmm.
Steve Calabrese, who's a professor at Northwestern. Probably I most frequently debate John Eastman, who's a professor at Chapman. For 17 years, John and I did a weekly radio program on the Hugh Hewitt Show, mm-hmm. Where we debate each other. And in fact, we're doing it again over these next few weeks, once a week, in light of the Supreme Court decisions. They're all terrific, and always enjoy the opportunity to have discussions with any of them.
Well, thank you for taking time out of your busy, crazy, hectic schedule, particularly this time of year, to be with us, our Orange County group and people from around the country.
I'm
Dean
delighted
Chemerinsky,
to.
Thank you. We hope to see you back next year. Everybody, thank you for participating. Watch the news, read the news, be educated. Doesn't matter where you are on the issues, just be educated. And thank you for sharing your perspective. Thank you, guys.
Thank you.
Bye-bye. Okay, Dale. Goodbye, everybody. Lots to think about. Bye, Browers. I see Jeff Pavlis. Howard Dragatsky, nice to have you. Bye, everybody.